Okay, so we're here. Um, so about 2 or 3 days ago, Disney, the parent company of Marvel, went ahead and basically submitted a response to Scarlett Johansson's complaint. So here is some real quick civil procedure for anybody trying to understand how does this whole process work. I think it's a little bit important because I think it can kind of help explain um, why you know certain activities have happened in certain actions, and if you were curious as to why I didn't say anything about this when Disney released their press statement. So the way a lawsuit works is that the plaintiff is the person who is suing, the defendant is the person that is sued, and the plaintiff has to show that they have standing. And standing is essentially a three-pronged stool. First, you have to be somebody who is hurt. All right, so you have to suffer an injury. You actually have to be injured in some way. Two, you have to be able to point a finger at somebody. You can't say somebody hurt me, but I don't know who. You'll get thrown out of court. You have to say somebody hurt me and they did it. Okay, and then the third thing is you have to say and that the court can fix what is wrong with me. All right, those are the three things that you need to have in order to have a to pass just the bare minimum of getting into a courtroom. And and when you do that, you put all that in writing. You put your whole entire staying issue into writing, and with it, you have what are called counts. And the counts are basically saying like, I was hurt in way one, count one. I was hurt in way two, count two. I was hurt in way three, count three. So on, so on, so on, and so on. And then usually you have like some factual background. And factual background is really just for the court to sort of understand like when you're looking at the situation, you need to know these other things to make this make sense. A really good example is like the movie Dune, or the book Dune. The book Dune, I have not read, but I know that it is a very, very, very dense book that is very difficult to read. So much so that the book has a book to explain what it is. Because unlike a lot of books, Dune does not try to make it easy for you to understand what's going on. Dune does not say, "Hey, by the way, this person is that thing and this person is that thing." Dune acts as if you already know what's going on and then moves forward. So the glossary, the dictionary, and the companion pieces are all there to give you that context that the book refuses to give you because in its world, you should know what's going on in the world. And so that's what Scarlett Johansson filed. What she filed a few weeks ago was her complaint. And essentially, she had at its core one real issue. So complaints have to be are very technical instruments. That's to say that you can have two complaints that are extremely similar. Now, from the course perspective, you must have both of those particular issues, right? So, for instance, you could say, like, you might have just totally made up. Complaint one, complaint one, count one might be John kicked me in the shins, and count two might be that he hit me with a skillet. Now you might say, oh, the complaint is that they had a fight or you're beat up. There are technical reasons why you have to list those things out differentially. But when you really looked at what she was complaining about, what she was truly complaining about was that she was owed a certain responsibility or duty from Disney to act from Marvel to act in a certain way, but that Disney came in and was like, "No, I'm going to squash all this right here and right now." So her complaint was that her company, and she's the only product that her company makes because she's the actress. Her company made an agreement with Marvel that ScarJo would appear in Black Widow and that she would perform and that she would be paid a flat rate. Additionally, that part of her compensation basis would be that she would receive a percentage of the box office receipts from the theatrical wide release of the film Black Widow. And and Scarlett Johansson's legal team believes that or the argument that they're making is that in the industry of filmmaking in LA, everybody knows that a theatrical wide release really means an exclusive theatrical wide release. There's another component to theatrical wide release, which is to say that it's supposed to be 1,500 screens across the nation, which everybody agrees. Disney, Marvel, ScarJo, they all agree that Disney allowed Marvel to do that. Their issue is about the exclusivity issue. Scarlett Johansson, because that's actually how you say her last name, Scarlett Johansson argument is that her bonus, the money that she would have made from the theatrical release, the box office percentage that she would have made, would have been higher had Disney not interfered with her contractual relationship and obligations that Marvel owed ScarJo and that ScarJo owed Marvel, namely that ScarJo and Marvel had agreed that ScarJo would perform and that Marvel would release the film exclusively in theaters. Now, if we read ScarJo's complaint, her legal team kind of skirts around the language of the actual contract, because the actual contract does not actually say that it will be released exclusively in a theatrical wide release. If it did, I would be right here saying that ScarJo has an amazing case and Disney needs to find a way to pay up because she's right. What it actually says is that she would have a wide theatrical release, which is 1,500 screens, which is exactly what Disney did, and no one disputes that. The issue is whether that was exclusive or not. So there are these things called cans of construction, contract interpretation. Basically, there are these default rules that exist in every state in the union, where if there is a dispute about a contract of how you're supposed to read or review that contract, so it can give the most effect to what's actually being presented therein. And so in California, essentially, they have the provision that basically says, all right, here's what we got going on here. We read the text of the contract as it is. We do not read into it, but we also do not read out of it. Now, if this were Delaware, this would be an extremely easy case for Disney, because Delaware as a state is all about contracts. So many companies are incorporated in Delaware. One, because it is extremely cheap to incorporate in Delaware as opposed to some other states. Like some states, it can cost you up to $500 to incorporate, whereas Delaware, I believe, is like $50, $25. But also, because people incorporate there so much because it's so cheap, Delaware state courts have an extensive history when it comes to how about contract interpretation rules. Like they have a whole thing about how they do this, and so they're very good. But they're very good, but they're very reliable. You kind of know what you're getting yourself into, as opposed to other states where, depending on the judge, the county, the parish, you may get outcome A or you may get outcome green. You have no idea what you're going to get. Whereas with Delaware, hot damn, you know exactly what you're going to get, because they're very much a contract is a contract is a contract. They do not look at outside evidence, which is called parole evidence. They don't look at that. They look at the contract, unless the contract allows it or there is something so wanting that you have to. But they are loath to look outside the contract. And because of that, a lot of people will say, hey, we can have our dispute anywhere in the United States, but it doesn't matter where we go. We will ask whatever court we're in to act as if it were a Delaware court, or in most cases, we will go to Delaware. For instance, let's say you have a dispute with your painter, and in your contract you say, you know what, we will handle the dispute here in Cook County, in Cook County, Illinois. However, we have chosen that the law we want to apply will be Delaware law. That'd be sort of an odd mix, but nevertheless, that's something that happens quite often. And so you have these well, the cans of construction are more for judges, but you have these contract interpretation rules. And so these contract interpretation rules are kind of interesting, because if you're curious, it's section 3294 California Code, Article 3. It talks about like damages and how the whole system works. And so you have a situation, and I want to make sure I get the exact language out, because The language, getting the exact languages, I'm sorry, and it's Civil Code 1638. Intention to be ascertained from language. The language of a contract is to govern its interpretation if the language is clear and explicit and does not involve absurdity. It is not absurd on Disney's part to say you bargained with Marvel for wide release. Marvel gave you wide release. However, there's another part of that that can kind of cut into Disney's argument. And that is Civil Code Section 1644, words to be understood in usual sense. The words of a contract are to be understood in their ordinary and popular sense, rather than according to their strict legal meaning, unless used by the parties in a technical sense or unless a special meaning is given to them by usage, in which case the latter must be followed. That is to say, words in the contract are to be understood how everyone else understands them. All right, so you don't get to say, well, me and the boys understand it to mean this. It's like, no, we're not doing specializing little words. We're saying it has to be what everybody else does. Now, typically speaking, this means this you are bound by geography. So if you're somebody in like here in Cook County, we like mild sauce on like Harold chicken and French fries. I don't have to explain what mild sauce is because here that's common. The issue would be if I went to, let's say, Alabama, they may not know what mild sauce was, and under these rules, it would be whatever mild sauce is in Alabama, unless I made it very clear in the contract that even though I am in Alabama, I mean mild sauce as it is understood in Cook County. Why is this an important issue for ScarJo? The reason it's an important issue for ScarJo is that her argument is going to boil down to really one thing, and it's two words: Disney Plus. She's going to argue that when her company and Marvel came together to form this contract that would allow her to work and act in Black Widow, and then Marvel would pay her for it, that they were not using ordinary and popular sense meanings of the phrase widescreen theatrical release. That they were using a technical or a special meaning for that was known by the parties, and that technical special meaning was exclusively theatrically wide released film. That's her argument. That's the whole kit and caboodle. If she loses on that one area, everything else falls apart. Okay? Because that's Civil Code Section 1644. If you look at Civil Code Section 1645, it explains technical words. Technical words are to be interpreted as usually understood by person or persons in the profession or business to which they relate, unless clearly used in a different sense. And so now the question is that is a wide theatrical release a technical word or phrase or not? Disney is going to say it does not matter. This is not their best argument, but the argument is going to be it does not matter. At the end of the day, we gave her a widescreen theatrical release. We did the words. ScarJo is going to say that even though the word exclusive is not there, it is read into that by everyone else in the profession or in the business of movies. And therefore, there's been a breach. But we need to talk a little bit about how ScarJo actually filed her complaint, because how she filed her complaint is very interesting to me. And if you happen to follow me on Twitter, my handle is literally my name, Arthur Mingo, and the number 1. So it's Arthur Mingo 1. I couldn't get Arthur Mingo, which kind of sucked. If you follow me on Twitter, I did like a whole 27, 28 tweet thread about her contract. What's really interesting about her contract is who she sues. Remember, in standing, you have to say, I've been hurt, they hurt me, and you can fix it. And real quick, when it comes to the I've been hurt, it has to be a real and particular injury. You just can't simply say, oh no, uh, 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 I was hurt because as I was driving down the street, I saw somebody run a stoplight and I felt bad. That's not gonna cut it. You have to show like you've actually been injured in some manner. You have to. That's for the I've been hurt. You have to show that the other party is the one who actually hurt you. And the third thing is you have to show that the court can fix it. That if the court steps in, that they can remedy your problem. That they can put everything the right way. It's the second issue that's really interesting because she does not sue Marvel. She sues Disney. Now, Marvel is owned by Disney, but technically, she did not contract with Disney. She contracted with Marvel. And in my little tweet thing, which is very long, I basically said, this is a problem. And she's doing it for, I don't know about the relationship, but for the technical reason, she's probably doing it for two reasons. One, she feels that if Disney was actually an intervening party, that's to say that Disney stepped in between the contract between herself and Marvel. But two, it's a legal theory called deep pockets. You always want to go for whoever has the deepest of pockets. So that way, when you ask the judge to fix it, and typically the way judges fix it is they will give you money. You want to be able to get the most money. So, for instance, if let's say you're walking on the street, you're walking the crosswalk, and a 15-year-old, a 16-year-old kid who has his driver's permit, learner's permit, is driving, runs a stop sign, and hits you. Right? You could sue that kid, but 99 times that kid has no money. But you might want to sue that kid's parents. They may have more money. And they're the deep pockets. Now you might be thinking to yourself, well, the parents weren't involved. Why would you sue the parents? Because the parents gave the child permission to drive. And they owed a duty to the world in general not to have an irresponsible child who doesn't know how to drive, stop, brake, or do anything, drive their vehicle. And the fact that they gave their child those keys means that if the child's guilty or is liable, then they are liable as well. You're going for the deeper pockets. Right? Because parents typically have more money than their progeny. So I think those are really two reasons why she did it. But there's a problem. And the problem is that her complaint kind of comes off a little bit catty, but really it never implicates Marvel. Her complaint never says Marvel, because typically in a situation like this, you want a complaint that says this: my name is Scarlett Johansson. I made a contract, I made an agreement with Marvel, and Marvel breached. But the reason Marvel breached their contract with me is because this other guy over here, this mouse, got in the way. So I have to sue both of them. But really, I'm not mad at Marvel. I'm mad at Marvel because of Disney, and therefore Disney is really the person with my ire, not Marvel. Unfortunately, I can't get straight to Disney, so I have to go through Marvel to get to Disney. Again, like our example, I can't sue child's parents directly because directly they don't owe anything to me, but I will say, like, if the child is liable, they are liable. So you sue in that manner. Kind of like the hook. And she doesn't do that at all. Doesn't do that at all. And so one of the things I said was that I was willing to bet a dollar that if and when Disney responded, that there were a few things they were going to say. And I annoyed some of my friends talking about this a lot, and then I had to shut up because I knew I was annoying them about it. So, real quick. I said, one, Disney's probably going to ask for this case to be dismissed because it's the wrong person being sued, or warranty. But that really doesn't really deal with the issue at hand, so they may kind of wave that one away. But I said the real thing that they're going to do is that they're going to say, Your Honor, this case should be dismissed or at the very least suspended until we do something else, and that's the FAA. And no, we're not talking about airplanes and the shooting stars. We're talking about the Federal Arbitration Act. Now, you may not have heard about it, but I'm telling you right now, it has impacted your life in more ways than I can count. the Federal Arbitration Act, in my opinion, is the bane of the legal world right now. There are things, to be honest, that are more pressing issues inside the legal world. But one of the things that really just puts a crank in my back is the Federal Arbitration Act. And the reason why I do not like this law at all is that the Federal Arbitration Act essentially says that if you have an arbitration clause in any instrument, so long as the arbitration clause impacts interstate commerce and is under the jurisdiction of the federal government, you cannot go to court. Period. You just can't. And some arbitration clauses will even say, like, so let's say you have a contract with somebody and you're like, I'm not sure if the arbitration clause applies or not. Like you're working in good faith, but you're generally like, I don't think this applies. Some of those contracts will say that the arbitration people themselves are the only ones who can decide whether or not they apply. Like you can't even go to a federal court to say, we don't think it applies to us because, you know, it said for items 1 through 5 and we're dealing with item yellow. Yellow is not 1 through 5. A federal court will have to dismiss that, saying, I can't answer that question for you. I may have thoughts, but I can't answer it. The only people who can answer it is whatever arbitration system you have agreed to. Why do I hate this? I hate it because companies, especially for consumers, tend to go ahead and will pick obscure arbitration companies, obscure locations, and require so much upfront capital that makes it very difficult for people to sue. To wit, imagine you bought a brand new computer. You bought from an OEM like Dell, HP, whoever it may be, and you have a problem with it, and you're like, oh, this is defective. And your OEM's like, no, it's not. So you go back and forth, and you're like, I'm going to sue you. So you go to your local state court, and it's like, hey, I've been hurt because the product that I bought is defective. The OEM made the defective product, and the court can fix it by making the OEM either return my money or give me another thing. If you have an arbitration clause in there, you can't do that. That OEM is going to ask for the case to be removed to federal court, or they'll just ask for the FAA to apply straight away. And by the way, if they ask to take it to federal court, when it is in federal court, they're going to ask for it to be taken away because of the FAA. And then when that happens, you may have to go to arbitration in Switzerland 4 to 6 months from now, after you pay $5,000 to the arbitrators to do their job. This happens on so many things all throughout the country. And also, the other reason why I do not like arbitration, I like arbitration, but I don't like the FAA, is that state courts and even some federal courts have tried to carve out exceptions for cases of fraud, abuse, other typical contract defenses or contract negligence that is done. And the Supreme Court has essentially said, we don't care about any of that. The FAA applies, and therefore, we will not speak on this. This is something that we will not deal with. So, you know, you have situations where people have found out that the company that a company they've done business with or they are a customer of has not only screwed them over, but has screwed over a whole bunch of other people over. And so in those cases, you might want to have a class action lawsuit. You know, we're going to round everybody up, and then we're gonna all collectively sue Facebook, and then we're gonna say that Facebook, you know, did us dirty. Well, when you sign up for Facebook, the terms simply say you must go to arbitration, and also you cannot do class actions in arbitration because that's what the clause is. Like, you actually can have a class action side of arbitration, but the arbitration will say, 1, you can't be a party, you can't join any class action lawsuits. 2, all disputes must be handled in arbitration. 3, all disputes must be handled individually in arbitration. So you have a situation where you may have people whose rights are trampled and they never know about it, because at least with a class action, it's probably going to be on the news. People are going to get little booklets or postcards in the mail that tell them, like, hey, you may be part of a class. Like I am part of a class for EpiPen because my EpiPen was defective. Good thing I didn't need the EpiPen because I am definitely allergic to a few things, and that would kill me. I am not going to say them. But nevertheless, if my EpiPen came with an arbitration clause attached to it, I would never know I had a defective EpiPen. And more than that, a lot of times these arbitration clauses will also specify that once you have decided to go to arbitration, so let's say you get your plane ticket to Switzerland, you wait your 4 to 6 months, you pay the $5,000 retainer. A lot of times, those arbitration clauses will say at the very beginning, "Oh, by the way, you can't tell anybody that you went to arbitration. You can't tell anybody about what happened. You can't talk about it at all." Now, companies will say they do that to protect the brand. But think about this. If you are a consumer, you're out there in the marketplace and you're trying to find what's the thing that works best for you. Wouldn't you want to know about a company that continues to screw over customers, that puts out a bad product, that does these type of things? I guess you probably would. But these arbitration clauses are really good at making sure it doesn't happen. And I want to say it's not that these arbitration clauses are written so well. It's that the FAA is the ultimate backup. The FAA is the Thor of the Avengers. When everything else is going down and you hear thunder and lightning, you know you're about to save the day. So there are times where some of these arbitration clauses are really poorly constructed, and the court will say, "Well, we get the intent. We're going to just take some tape. We're going to take some duct tape, patch up a few holes, and send you on your way." And that's what happens. And that is what Disney did. So let's talk about Disney, the House of Mouse, as I like to call it. So essentially, Disney went ahead and filed a response. Now, a response is basically a legal document that says, "Your Honor, in the words of my cousin Vinny, everything they say is a bunch of bullshit." Okay, that's basically what it is. And we don't have Herb Munster going, "Try that again, counselor." And by the way, My Cousin Vinny, one of the best legal movies I have ever seen. Anywho, so when Scarlett Johansson made her complaint, Disney has a certain number of days to respond in writing. Otherwise, there's a very strong possibility that the court, although the court would give more than just one notice, the court may rule in her favor even if Disney doesn't show up or appear, because at some point we gotta get this moving forward. And what they basically say is, "There's a bunch of bull," all right? And so what they ask, because I want to make sure I get the name of it right, what they ask is for a notice, a motion to dismiss. Because at the end of the day, they're basically saying, "Your Honor, her contract with our entity, not with us, with our entity, requires her to go to arbitration." Now, you may be wondering, why did she sue Disney and not Marvel? And Disney says, which I think they're absolutely right, that part of the reason why she did it was that she felt, if I sue Disney, I can get out of the arbitration clause and go to court. Why would she want to go to court and not arbitration, you're asking? Well, I'm glad you did, person who's not there. The reason why is that, typically speaking, those arbitration clauses, sometimes, and I don't know what hers has or what hers says, sometimes they will say how much you can get in damages. They have a pre-cap. Whereas if you go to court, if you have a bench trial, which is that you have a judge who is not just there as like a referee, but is actually actively involved in doing the things that a jury would do, that's what we call a bench trial. Or if you have a jury trial where the judge is acting more like a ref, like Law and Order, like a ref, but the jury is the one who's making the decision of like liable, not liable, which is the civil version of guilty, not guilty. You have no idea, none, about how much money you could possibly lose. So you send to arbitration, and either A, you make explicit in your arbitration agreement, like this is how much the fees how much we could lose, our downside will only be this deep, or you pick an organization that you know by their own internal rules simply state like, we never go past this number. That way you have that kind of guarantee, like here's how much I know I may lose. And so that was part of what she did. So she wanted to get to court because otherwise she would have to go back to arbitration. So let's talk about what they said. So, unlike Scarlett Johansson's complaint, Disney's response is actually chock full of cases. Scarlett Johansson's lawyers, I think they did the best they could with what they have, because the FAA is definitely right there. It is just lurking about like a thing that lurks at night and is ready to pounce on you. And so part of ScarJo's idea is I can get out of this arbitration by suing Disney, and Disney's like, no, you can't. And the reason why you can't is because at the end of the day, one, we didn't contract with you, but two, you're really trying to say what you're really trying to say is that we prevented Marvel from doing their thing. And if you're saying we prevented Marvel from doing their thing and giving you the extra money that you believe you deserved, well, then that's a contract dispute between you and Marvel. I mean, we're there with our boy, but really, it's a contract between you and Marvel. And you and others have tried this move in the past of trying to sue a third party to get around an arbitration agreement, and you know you can't do that. You know you're not supposed to do that. And that's exactly what they said. And so the bet that I made with myself is like they're going to ask to remove this to federal court or ask for it to be dismissed on the FAA. And that's exactly what they asked for. That is exactly what they asked for. And so one of the things, like reading Scarlett Johansson's complaint, there are times where the complaint to me reads as if it was not written for a judge. It reads to me as if it was written for the public. It was written for CNN, Fox, MSNBC, Vulture, THR, the trades. It was not written for a court. And Disney's response to me feels more as if it was written for a legal court, for lawyers or for the court. Just the word choices and the way they frame things. They frame things in a very legalistic manner, and not in a negative connotation, but more like this is the law, this is how the laws apply, and not so much like and Scarlett Johansson just greedy. I will say this: their press release was written for the people. Like that right there was not written for the law. That was written for the people. But their response is actually written for the law and not for the people. And so they, in their response, they don't just say, let's talk about the FAA. They first they want to talk about, they try to talk about her actual issue and then why at the end of the day this court doesn't have jurisdiction over it. So they basically sum up her argument. Her argument is this, that Marvel breached by releasing Black Widow on theaters and Disney Plus, and that the contract expressly provides that any theatrical distribution obligations are satisfied on no less than 1,500 screens. I will say this: they don't write in her real issue. Her real issue is not the less than 1,500; it's the less than 1,500 exclusively. But those are her two issues. And so then then Disney starts to talk about how much money the movie made. Now, I do not have the details of her contract. It just has not come out yet. If it doesn't come out, I will be doing a part 2. But what her contract, what the impression that Disney leaves is that one of her arguments may actually be sort of false. I don't want to say false, but she may not be telling the whole truth. If you read her complaint basically says, I was promised the side pot of money that's from the box office receipts, and I don't get any of the D Plus Premier Access money. I only get the box office money. And if there was no D Plus Premier Access, I will be getting a larger box office money because that will be the only way you could experience Black Widow. But now because you can experience it in the theaters or on the D Plus platform, I'm losing out on that D Plus platform money. The thing is, if you read Disney's response, it almost sounds as if she got cut of the Disney Plus money as well. And for that, I want to go ahead and read exactly what it says, because it does sound like she's getting some of that money. So if anybody is looking at the defendant's notice of motion and motion to compel arbitration, and state court proceedings, which is what you would say, basically say like you're not asking for the case to be dismissed, but you're saying like pause it, we gotta go someplace else. Um, Page 9, line 17, and it says this. And it's we mean Black Widow, the movie. In its opening weekend, the picture Black Widow grossed more than 80 million in the domestic box office, an opening weekend record for the pandemic, and nearly 10 million more than Universal's F9 of the Fast and Furious franchise, which was released exclusively in theaters and set the record 2 weeks earlier. The picture, Black Widow, also earned more than 78.8 million in international box office receipts in its opening weekend, for a total worldwide debut of 158.8 million. In addition, the picture grossed more than 55 million in its domestic opening weekend from Premier Access on Disney Plus. As an aside, when I say D Plus Premier Access, I mean Disney Plus Premier Access. I may end up just turning to D Plus PA, but that's what I'm referring to. And here's an important part: when the 55 million in D Plus PA receipts is added to the 80 million domestic box office total, the total domestic box office, and they do have it in quotes, for the opening weekend was more than 135 million, more than that of many other Marvel Cinematic Universe films, including Thor: The Dark World, Ant-Man, Ant-Man and the Wasp, and Guardians of the Galaxy. I'm curious as to why they picked those films, but they did what they did. As of August 15th, 2021, the picture has grossed more than 367 million in worldwide box receipts and more than 125 million in streaming and downloaded retail receipts. So, the fact that they're putting together the physical box office of you going to the theater, the cinema, and paying and singing in the room, and what you really get on Disney Plus PA, it sounds as if ScarJo is getting both of those, which makes her argument a little bit less, because if you read her complaint, her argument was that the fact that it was not exclusively in theaters impacted how much money she made. And that she would have made more money had it only been on theater screens, and that she did not get a share of the D Plus Premier Access money. If this reads the way that I believe it reads, it means that she got a share of the Disney Plus Premier Access Black Widow money, which makes her claims even harder for her, which adds a burden to her, because now she has to prove that about the exclusivity issues. Because Disney is going to say, not only did we give her the 15 screens, we were not required in our contract, which they make a point, again, we don't know what the contract is that Marvel has with Scarlett Johansson. She was not required, they were not required to pay her from any Disney Plus Premier Access. If she's actually getting that money, that shows that Marvel was acting in good faith. Okay? And so then they go through a whole issue of then they go through. I'm sorry, just making sure I kept up with my notes here. Then they go through the whole complaint that Scarlett Johansson's company Periwinkle has with Disney, and for anybody who gets it, Periwinkle Blue. And so then after that, Disney's like, okay, how about we go ahead and send arbitration? Because in the contract you have with Marvel, that's step number 2. And they sent that paperwork to her team, and her team hasn't responded to it at all. She just refused to do it at all. They then talk about how they've done it, how they kept up with the spirit of the whole thing. And then there is the FAA. And here's why I think Disney's going to win. Not that I think what Disney did is right or wrong, but just on the legal issues alone, I think Disney's going to win. Because in order for the FAA to apply, one, there has to be a contract. 2, it has to have an arbitration clause. And 3, it has to come under the purview of the Federal Arbitration Act, the FAA. We know there's a contract. Do it. We know it has an arbitration clause. Or do we? It seems as if there is. If they are lying to the court about there being one, that's a real bad move, and the judge may sanction them pretty darn hard because of that. According to Disney's response, there is a broad arbitration provision. And so now the question is this an arbitration agreement that implicates the Federal Arbitration Act? Because if it does, then at that point, time to send over to the FAA. I'm saying it's time to send over to whoever is an arbitrator inside of the FAA. Federal laws favor enforcement of arbitration provisions. States have tried so hard to break their citizens free of the FAA. And what always happens is that if that contract implicates interstate commerce, and by the way, interstate commerce is the reason that we have almost 95% of our laws as one section. The majority of federal law is based on interstate commerce. If it implicates interstate commerce, that is to say that there is some intercourse between the states' commerce happening back and forth, then at that point, you're subject to the FAA. Is it subject to the FAA? Well, they signed it in California. She performed it in Atlanta, Georgia, which is a different state. Marvel's performance was supposed to happen nationwide. That is interstate commerce. So, now that it's subject to the FAA, now you have to make sure there's nothing wrong with the arbitration clause itself. The few times that federal courts will step in and remove an arbitration clause is if the clause is so defective that it can't be saved, then they will. So if an arbitration clause says, party A's total damages can be no more than $1, but party B's damages can be as high as ever. Party A picks the arbitrator, and it's always party A's brother. Like, it has to be really, really out there, really obscene for the court to go, you know what? There's no way that the FAA was designed to help this, and we're going to kick it out. But rarely do you see arbitration clauses that bad. I have never written something that bad, and no one that I know has ever written something that bad. So then they have then they actually start to list out parts of the language. And it says, all claims, controversies, or disputes arising out of, in connection with, or relating to this agreement, the performance of breach thereof, whether based on contract or tort law, shall be arbitrated. That right there pretty much seals the deal, because her claims arise out of and are in connection with and relate to the agreement and the performance and her alleged belief that there was a breach. Therefore, the Arbitration Act applies. Now, they have to go on and on and on. Oh, also, evidently we didn't know this because there are some things that are just not available online. You get like complaints and responses, but some of like the smaller things you can't find online unless you're actually a part of that judiciary, that circuit, and then you can actually get a copy of the paperwork. But evidently, Scarlett Johansson, people believe that what she wanted a California court to apply New York law about a dispute that happened in Georgia and across the country. And she essentially says that the FAA should not apply, but New York law should apply, and because of that, this case can proceed forward. Disney makes a point saying, well, New York has their own version of the FAA, and their version is not that dissimilar to ours, and therefore you should still go to arbitration. And so because of that fact, it doesn't really matter whether or not you're going to arbitration, because the state that you want will give you the exact same result. You'll just be in state court instead of federal court. And if state courts around the country or anything like Illinois state courts are awesome, but they're real loose with the rules, whereas federal courts are real sticklers for the rules, and it can be annoying, but it makes life a lot bit easier. The next thing to talk about is just essentially like how Scarlett Johansson cannot go through, can't skip arbitration by not saying Marvel, and then as Disney is a third party beneficiary, because they receive a benefit from the contract between Scarlett Johansson and Marvel, that they can step into Marvel's shoes and enforce the arbitration clause, which is well-established law and is also a part of the FAA. So then they get to the very end, and the very end is basically just saying, hey, the FAA applies, please suspend this action and send this to arbitration. Force her to participate in arbitration. They're basically, and that's it. I generally do believe that Disney is going to win. This case will go to arbitration, and when it goes to arbitration, we will not learn anything else about it. That is, unless Scarlett Johansson's legal team decides to disclose facts about it, but nothing will be publicly filed. The only reason why I have her complaint, or the complaint and Disney's response, is that in court, all this stuff is public information. You are allowed to read it. You are allowed to sit in court sessions even if you have nothing to do there. Not right now because of COVID-19. But normally speaking, you can just go into a courtroom and just sit and observe and watch. You don't need to have a reason to be there. With arbitration, that's not the case. Remember, arbitration is a private dispute resolution system. It is not judicial. It is not a part of any state's constitution. It is not part of the federal constitution. It is a privately regulated, privately dispatched resolution system. It is squarely about two private parties have given a third private party the ability to figure out who is right and who is wrong. And because of that fact, you will not learn things, especially if in that arbitration clause, we don't see all of it. We don't see part of it because only Disney puts it in their response. Scarlett Johansson does not put in her complaint that I saw, and I'll read it again just to make sure, but it is not in there. But nevertheless, because of that fact, we don't know if her arbitration clause says that it is an NDA. You can't talk about it. A non-disclosure agreement. Like once you are a part of arbitration, we don't talk. It's like Fight Club. What's the first rule of arbitration? We don't talk about arbitration. And if her legal team were to leak, or if there were a leak to happen of those documents, it would be good to see them. But I can't, and neither could a lawyer in California or New York or in Georgia just go to the courthouse like, hey, I want a copy of that paperwork. Just not going to happen. So when it comes to the issue of Scarlett Johansson versus Disney, the spider versus the mouse, I think the mouse has the knockout punch here. I think from a PR perspective, I'm not a PR guy, but from a PR perspective, Disney don't look all that good. But let's be honest, it's the House of Mouse. Everybody kind of knows what they're about. They're about that sweet cash. So I mean, for as much as they may take a hit in PR, people are going to kind of move on and come right back for Shang-Chi, The Legend of the Ten Rings. They're coming right back for The Eternals. They're coming back for Spider-Man and Fantastic Four and Blade and Guardians of the Galaxy Volume 3. They're coming back for, live-action remakes of old cartoon movies. They're going to parks. They're going on cruises. People are not going to leave Disney over Scarlett Johansson. There may be a few, but it won't be enough to really impact the bottom line. And so to a certain extent, Disney can afford to act in this manner because whatever negative consequences they have, they can probably be absorbed in one quarter's worth of work. But legally speaking, I think Disney is on much surer footing than Scarlett Johansson. The only thing that will kind of get in their way will be the issue of exclusivity. And even that issue of whether or not it's exclusively 1,500 movie screens and not on a streaming service, or if it is on a streaming service, even that issue cannot be dissected by this court. That has to be dealt with inside arbitration. Again, once you figure the FAA applies, everything else stops. So the issues about the industry standard of what does exclusive 15 wide release, none of that will happen in the public sphere. All of that will happen inside of arbitration. And again, unless the parties contract and agree to allow us to see it, we won't see it. So I'll keep you all up to date as to what happens. I'm sorry I wanted to make this 40 minutes and when we're at 15 minutes, but there's just a lot in here. Plus, I didn't start at the very beginning. I started off 5 minutes into it. So really, went over by 10 minutes. I apologize. I will try and make these shorter. Next week, Thursday, I am going to cover the Kraken. The Kraken. The Kraken is our team of lawyers who believe that there was some evil doings going on in the state of Michigan for the 2020 election, and they sued, saying that they represent people who were hurt. The state of Michigan hurt them, and the only way to fix their hurt was to change the election results. And then things didn't work out for those lawyers the way they planned, and then the state of Michigan and its local units of government then turned around and sued the Kraken, basically saying they've wasted the court's time, they've wasted our money, they knew what they were doing was wrong, and we want you to punish them for that. There's been a ruling. I'm not going to get ahead of the headline. Please don't look it up. It's a fun talk. But there's a lot there that I want to discuss because, my God, if you are in law school, if you are preparing to take the bar, if you're a new attorney, you've been practicing for 10, 15, 25, 30, 35, 40, 45, 55, 55, 60, 75, 85, 95 years, and you ever have a moment where you go, man, I'm just not a good attorney, and maybe I should give up, maybe I should switch. When we talk about what the Kraken did, and the Kraken is a group of lawyers, you will always feel better about yourself. Needless to say, at some of the hearings, people cried. People were insulting to the judge. People tried to lie. Namely, I'm going to give away a little bit. Attorney Lynn Wood basically said, "Your Honor, at the hearing, I don't know these people. I don't see nothing. I don't hear nothing, and I'm not saying nothing, except for the fact that when he was in Delaware State Court, he was like, oh yeah, I'm with those guys in Michigan. Your Honor, I'm doing big things in Michigan, and there's a whole big thing." It will take an hour, so I apologize now for how long it will be. I will have lots of water because that will be even more talking, and I think I might even like post documents ahead of time in case people want to read along. But there's a lot there to go through, and I think it really is a great example of legal ethics are very, very, very important. And despite what pressure may have been pushed onto me, I have never violated my legal ethics, and this is an example of why you don't take bad choices. Like, everyone is entitled to have their day in court, but you are not entitled to abuse the system. And we will find out whether or not what they did was considered abuse, and if it was considered abuse, whether or not they were punished. But all in all, guys, it's been a great chat. I hope this was helpful. Y'all have a great day, and I'll see you next week, Thursday.